Good morning. May it please the court. Paul Sorrell, and I'm here with my colleague Ingrid Martin, and we're appearing here on behalf of Dr. John Doe. The case before you today, we're being asked to review, or we're asking you to review, a decision in the Superior Court by Judge Spurlock, which held in effect that Dr. John Doe is not a psychiatrist within the meaning of the privilege statute 233(20)B, and as a result, that he was unable to assert on behalf of his patients the psychotherapist's patient privilege.
Let me just ask you a question. I may be way off, but in this case at least, why wouldn't it be workable to treat the privilege as in place for purposes of this case, just say it's okay, without conceding that it is a privilege, and simply redact the names? Because I wouldn't think that the board would care whose record it is. The question is just whether the prescription was appropriate for the diagnosis. So if you call everybody patient ABC down to Z or whatever, and you write out the diagnosis for that patient and the prescription for that patient, would that solve everybody's problem?
Well, respectfully, Justice Cowan, I don't think that it would. Number one, the board, of course, has the names A, B, C, and D. Number two, they would be comparing that to the...
What do you mean the board has the names?
The subpoena was issued to named patient. The board knows who these patients are. The board has, in fact, access to a lot of information, including the pharmacy records. So they would be matching, in fact, they would necessarily be matching the records, the psychiatric records of patient A against the pharmacy records of patient A, who they already know who patient A is.
And that's how they know
his
is
name.
that right? They know it through the pharmacy records?
That's through the pharmacy records and DEA records, whatever. I mean, they have access to to both pharmacy and DEA records as the investigator reflected in her affidavit. So they know who these patients are, and they would be looking to match precisely that, the named patient's prescriptions against the patient's records.
But isn't there a public interest here to ascertain just how deep this problem is? I mean, they know what his office practices are. They know how the kind of treatment that he provided to patient A. What they now need to know is what was the basis for his treatment of the other 23 people, because they need to know whether he is generally incompetent or whether or not his treatment of patient A was an isolated incident.
Well, first of all, they have the records of patient A, Justice Spina.
No, I know that.
Well, then I would suggest that if they thought there was any problem, any competency problem with his treatment of patient A, they could proceed right now. They've got his pharmacy records, and they have the treatment records of patient A. They don't need an investigation any further. They could proceed right now with the records of patient A. That would be number one.
Yeah,
number
but they
two,
also have information about his general office practices and procedures, and that suggests that this is a much deeper problem.
Respectfully, I think it suggests just the opposite. Let's talk about the information that they claim they have. They say this doctor prescribed 700, over a 3-year period, 770 prescriptions, 7,700 narcotic prescriptions, about an equal number of prescriptions for Valium to about 205 patients. Well, we would expect, for example, an oncologist to prescribe a lot of chemotherapy. We would expect an allergist to prescribe a lot of antihistamine. There is nothing untoward about a doctor who practices specialty is pain.
But there is one.
But here's what they don't say. Not once do they allege that a single patient got anything more than a therapeutic dose of the medication. They know what the therapeutic doses are. That's how they evaluate whether the prescriptions were any good.
But the question is not, excuse me, the question is not did he get a therapeutic dose, but did they get a therapeutic dose because they were suffering from chronic pain, or did they get a, quote, therapeutic dose even though they didn't need the medications?
And there is nothing anywhere in the record to suggest whether they needed the medications, though the board would suggest that they didn't. I mean, I would
but there
agree.
isn't there? Isn't it a reasonable inference to draw that a doctor who asks patients what your favorite color is, what kind of a car do you like, and that provides the basis for prescribing opiates is totally inappropriate.
Well, but Justice Spina, two things. Number one, we were denied the opportunity to have an evidentiary hearing so that we could challenge those assertions by the board's investigator as to what those questions are and how he uses them. I think that you have all
But you're
seen,
putting the cart before the horse.
No, I think not.
I mean, that's the nature of the investigation. You're not entitled to challenge an investigation at each step along the way.
Well, but then we come down, then what you're doing is, I suppose, engaging in the balancing test that the board is urging you to do, and that I would suggest is totally inappropriate here, because we're dealing now with a privilege. And we all know, there's no question, privileges stand in derogation to the truth. We know that. They're generally disfavored. But the opposite is also true. Those few privileges that we have are treated robustly, and at some point the legislature has made the decision weighing to what extent the privilege ought to trump the search for the truth.
May I ask you this? Would you agree that if the doctor was not a psychotherapist, there's no privilege?
I'm not, the short answer to that is no, because I don't think psychotherapist is defined in the statute. I think the question is whether he is in this instance, whether he is a psychiatrist whose substantial practice is in psychiatry.
No, but
and the answer is
privilege-
yes. So if he were not a
The privilege, though, goes to psychotherapists.
Okay, so
That's
if
the
he-
word used in the privilege
Oh,
statute.
okay, so if he were not a psychotherapist within the statutory definition, then of course the privilege would not apply.
And do you agree that he said that he practiced less than 5 hours a week with his patients as a psychotherapist?
No, I would not agree with that. What I would agree...
Didn't he testify to that?
No, he didn't testify to that, and that's, again, the issue of us having the opportunity to contest to have an evidentiary hearing about what Ms. Vaca had to say. First of all, Justice Ireland, Dr. Doe practices by the board's own account.
Maybe I asked the wrong question. Did the board find that?
Did they find it? They alleged it. But again, he practices only 19 hours a week. Now, what he was saying was, as within every patient, and you have the records of patient A in front of you, they're in the record appendix, and you can see in the record appendix that for every visit, it says psychotherapy. And by the way, they've got the records of prior patients because they tried to take his license away before. And there was a decision at Dalla. The magistrate heard on exactly the same information, and here's what the magistrate found. The magistrate found that, in this instance, Dr. Doe, this very same doctor, that Dr. Doe practices psychiatry, that part of his that he's board certified in psychiatry, that part of his practice of psychiatry is pain management, and that pain disorder is a recognized disorder in DSM-4. That is the Diagnostic and Statistical Manual of Mental Health Diseases. So there is no question that that practice is psychiatry. The question of what percentage of any individual patient encounter involves some time, some 10 or 15 minutes of talk therapy, as opposed to medication management, which of course every psychopharmacologist, which is a psychiatrist, engages in, is irrelevant. But also, he's only working by the board's own affidavit 16 hours a week. So if he's even if you were to look at it that way, that he's practicing 5 hours of psychotherapy, that is a substantial portion of 16 hours a week. When we consider the word substantial in 38 context, we mean, what we say is it means something more than a scintilla. In addition, I'm sorry.
I'm over here.
Yes.
Mr. Sewell, it seems to me that there are at least two ways that one can look at this. First, as a general matter.
As a general, I'm sorry.
As a general matter.
Yes.
If the board has reason to believe that there has been something that contravenes the public interest, can it subpoena records that are covered? I'm just going to assume that they are covered by the psychotherapist privilege. That's point number one. And if they can, have they appropriately done so in this case? And it's not clear to me. You seem to be doing it on both grounds. One, they should never be able to do it. So we don't have to get, we may have to get to the factual question as to whether he's covered by that his patient notes are covered by the psychotherapist, but let's assume for the moment that they are. Is it your position that the board can never subpoena records that are covered by the psychotherapist's privilege, and or that in this case it's inappropriate to penetrate the psychotherapist privilege?
Respectfully, Chief Justice Marshall, my position is that they never can, as the law currently stands. That is, that the notion of a balance has been struck by the legislature. And I would hearken this court back to what it said, for example, in a similar case similar in the sense that it involved a privilege in the board subpoena, and that's the Choate Sims Hospital case, where the board attempted to subpoena in an investigative stage, the pre-adjudicative stage, attempted to subpoena peer review records from Choate Sims Hospital. And what this court says directly in that case is, if the board wants authority to obtain peer review committee records in a preliminary investigation undertaken before the board had begun a proceeding against a physician, it should seek authority from the legislature. This is a legislatively created privilege. It has 7 exceptions. We can presume that the legislature...
I'm sorry, excuse me. In view of that, when you say never, do you mean never at least until they commence a proceeding? And then under Chapter 233, Section 20B, subsection F, they can?
Well, I think subsection, we're not at that stage, so mercifully at this point,
I know we're not at that stage, but I'm
that,
trying to
yes.
understand whether never means never or never means at least until they commence a proceeding by filing a complaint.
My read of subsection F, Justice Gantz, is never. My read of subsection F, which does, by the way, reflect that the legislature did consider the licensure issue, that is, the board's public protection function when it wrote this statute, because it talks about licensure revocation proceedings. But as I read Section F as meaning that in instances where, for example, a patient has charged the doctor with misconduct, because it talks about relevant to his claim or defense. That so when it is relevant to the doctor's
claim or defense, not relevant to his claim or defense.
And I appreciate that reading, and to that I would say if that were the case, then I would hearken back then to the Coburn decision, because that is because this not only, Section F not only talks about revocation procedures, it also talks about in criminal matters. So in Coburn, which was a grand jury,
it was a grand jury proceeding.
But I think that's a criminal matter within the meaning of F.
You also had, in Coburn, you had the supremacy clause, which you would say doesn't apply here.
But I would...
this is in your favor.
Yeah, okay, then yes. But I think that in Coburn, they simply said that they didn't have to get to...
But the discussion is about the fact that it's the federal Medicaid law that is...
Right. I think that's true in Coburn. But I'm sorry, I just wanted to finish the thought with Judge Gantz, which is that Coburn never would have reached that because relevant to the claim or defense, if the records were relevant there, then the grand jury would have been able to subpoena them in a criminal proceeding.
My question is, could the board, at whatever stage, but could they, since they know the names of these patients, could they contact the patients and ask whether they'd be willing to waive their privilege?
Of course they could. They know the patient. They know where the patient filled the prescriptions. They have the patient names. They've done none of that.
Well, what if the patient exercised the privilege? If the office had burned down and all the files were destroyed, could the board subpoena patients 1 to 23 and ask them questions about their treatment with the doctor? And if each one of the patients said, I'm invoking the privilege, could they be required to testify?
My read of 23320B is no. I mean, I think we've created very few safe havens where people can unburden themselves. They can do it with a lawyer. They can do it with a priest. They can do it with a psychotherapist. And I think that the legislature has decided that on balance, particularly when you're given all of the other tools that the board has had. My God, look at what they've looked at here. They've reviewed thousands of pharmacy records. They have the right to knock on the door of any patient they want and ask. They can, if they think that these patients, by the way, there's no evidence that any of these drugs are being used in anything other than a therapeutic manner. But by the way, they've got a stable of investigators that they can watch the patients and see if they think that they're abusing drugs. They have a tremendous amount of investigative capacity and authority to in the narrow case of a psychotherapist, to still be able to conduct a pretty robust investigation without access to those records.
Well, but they can't determine whether the person walked in for no good reason and said, give me oxycodone. that would be revealed by the records. All that you would get from the pharmacy records was that he was indeed prescribed oxycodone.
And again, let's remember that these patients, if you saw from that information, they're also getting, these are psychotherapy patients. These are the patients of
That's
a
what you
psychiatrist.
say, that their contention may be that they're individuals who know that he's simply
here's
a
what we know-
dispenser of oxycodone, and he's the guy to go to if you want to get oxycodone.
Well, if that were the case, that information would be here if he's the guy to go to. His prescriptions would be on the street. They'd have information from folks. Look at what they did in the prior case. They had 2 undercover police officers who saw him over 30 visits, and the Dallas magistrate determined that there was absolutely nothing improper. And I just wanted to finish with regard to Justice Spina's question about this business with cars and colors and movies. You know, there are any number of ways to do a mental status exam. What a psychiatrist wants to know is a patient speaking coherently? Are they thinking concretely? Do they make sense? Any way you can start up a conversation, and that's what he's telling them,
But
that he
didn't
chooses to
say
do
if
it
you
that
like
way.
the color purple, that's a sign that you're malingering?
No, it's not. He happened to have made a couple of interesting observations. He doesn't make his decision that way, and this was thoroughly vetted at Dallas. And the Dallas decision makes clear, and the board walked away from the case after they went to Dallas in that case with undercover policemen who said all the same things, and we had a hearing with experts. The board case was dismissed, and it was determined that there was nothing improper in the way Dr. Doe was treating his patients and conducting his mental status exam. This is the board fishing around, trying a backdoor to come again at Dr. Doe when it failed to do so the first time, and I would respectfully suggest in contravention of the privilege, and I can't tell what that means.
It means that you have to stop talking.
But I have one,
I was afraid of that.
but may I ask one question? There's a pain management agreement in the appendix.
There is.
All right. Did each of the patients sign one of these
Well,
agreements?
that would be, what I can say to you is that it is his general practice to have that done, but I think I would be disclosing improper information if I
Well,
answered that.
would
You
you
could assume
agree
so.
with me or not that if they did, these include waivers of the privilege?
No, I think they only include waivers of the privilege if that particular patient has abused the trust. As patient A did. Patient A, it was clear. What the agreement says is, if I'm treating you for pain, the only place you're going to get narcotics is from me. And if you get them any place else, then you are no longer, because that's the look, let's be clear. Nobody does.
I'm just you don't have to go
Yes.
on and on. I'm just
Okay.
asking. Your
Yes.
view is that this would not be a waiver
No,
in
that's
any
correct.
event.
That would be my view, Justice Corey.
Thank
And
Thank you, Mr. Smith.
thank you so much.
Mr. Hammond, good morning.
Good morning, Your Honor. Thank you. Daniel Hammond, Assistant Attorney General for the Board. Your Honor, I'd like to start just by reminding the Court that the Court has held a number of times in a number of different contexts that where a privilege is invoked, the burden is squarely on the party invoking the privilege to show that each element of the privilege applies. So before we even get to the head-to-head conflict, and we will get there in a moment, I would just remind the Court
Well, he's a
that
board-certified psychiatrist.
Yeah.
So, okay. He's produced evidence that he's a board-certified psychiatrist.
yes.
And he asked for an evidentiary hearing to the extent that you suggest that he was not engaged, and he was denied an evidentiary hearing. So,
Well, the basis on which the Superior Court found that the privilege did not attach is not that he's not a licensed psychiatrist, but that he does not spend a substantial portion of his time, by his own admission, in the practice of psychiatry.
What does that mean?
How are we supposed to deal with that? If a board-certified psychiatrist is practicing, he says psychiatry, and pain disorder is a recognized psychiatric illness, or it's anyway in the DSM-4, is the court supposed to say, well, 72% is substantial, but 67% isn't? I mean, doesn't that get us into mind drawing that nobody could have meant the court to have?
Well, certainly the language in the statute is not very availing. To say substantial portion, it clearly doesn't specify
To the practice
a
of
proportion.
psychiatry.
In the practice of psychiatry, correct. But I would also say that, well, a couple of things. First of all, yes, while pain management is recognized as a subset of psychiatry, it's also a subset of a number of other disciplines, including neurology and internal medicine. But more importantly, to read the privilege as a whole, the privilege speaks to communications, and which at least suggests that the body of information that the legislature was concerned in keeping confidential was communications as between the patient and the psychotherapist in the diagnosis and treatment of illnesses.
But isn't that
Isn't that what
exactly,
you're
isn't that what you've asked for?
Yeah.
I'm sorry?
Isn't that what you've asked for?
Well, the context strongly suggests talk therapy. It suggests admissions made to a doctor and treatment ideas back from the doctor. It doesn't fit neatly with pain management as a separate discipline. It fits with, it suggests at least that what the legislature was trying to protect was talk therapy, not pain management.
But the definition of communications is extremely broad. Conversations, correspondence, actions, and occurrences relating to diagnosis or treatment, and any records, memoranda, or notes of the foregoing. I mean, that isn't necessarily just the back and forth between the patient and the doctor.
This is true. However, Dr. Doe himself drew a line between his pain management practice and his psychotherapy practice and his psychiatry practice.
How do we know that? I mean, what we have, as I understand it, and maybe I don't understand it, is
Yes.
we have an investigator's report,
Yes. But
and then which he contests, and there's no hearing to make a determination. In other words, it's possible, Mr. Hammond, but it seems to me not well established on this record that he has not been treating these patients as a psychotherapist. It's possible, but the record is very, very sparse as to that. Let's assume that he was treating them as a psychotherapist. He's a psychiatrist. You know, he may have drawn a distinction between pain medication, but let's assume that it is covered. I mean, we try not to split hairs. Isn't that the end of the case?
I'm sorry, the end of the case,
Well, if
I
he's...
lost the hypothetical there.
Well, assuming that he is a psychotherapist with respect to these 23 patients,
Yes. Okay.
then what? In other words, we've got a Superior Court decision that rests, as far as I can tell, entirely on the fact that the Superior Court judge concluded that Dr. Doe was not a psychotherapist, correct? So the Superior Court judge
yes,
did
that
not
was
go
the long
on.
ground, yes.
So let's assume that that we find error in that because there's nothing in the it's not sufficient in the record.
Mm-hmm.
Is that the end of the case, or do you say it doesn't really matter because we should be able to get them anyway, the records?
The latter, certainly. And just on the general ground that on appeal, an appellate court can sustain
No, I understand
the
that.
result reached below on any ground. I would first say, I quarrel a little bit, though, with your characterization of the sparseness of the record. It was not just the investigator's report that talked about the distinction that he drew. It was also Dr. Doe's license renewal applications in 2004 and 2006, where he also drew a line and said, in effect, the majority of my practice is in the area of pain management. I practice fewer than 10 hours per week. The first time, and I believe it was fewer than 8
Well,
hours a
Mr.
week.
Hammond, drawing further on that, I mean, you
Yes.
say that the judge below was right because Doe, as a factual matter, didn't devote a substantial part of his time to the practice of psychiatry, and the board's need for the records outweighed his assertion of the privilege. But why shouldn't there have been a hearing to determine both these factors? I think that's what the Chief Justice is driving at also. Why would there be a harm in having a hearing to determine whether there is evidence in the record to support those conclusions?
Well, okay, first of all, the way Chief Justice Marshall asked the question was, would that be the end of the case if we
No,
were
I
to
understand. You're
disagree?
going to take the
Right.
broader position. So it may be that we have to decide. There are two ways that we can go. We can
Right.
address the broader issue. When the board subpoenas, it's entitled to get access to privileged materials. And so we don't have to conclude in this case, except to say go back and have a finding. Or we could say the judge was correct, the evidence is sufficient to sustain that he was not practicing as a psychotherapist with respect to these one. So we don't have to reach the question. I'm trying to, do you want me to rest everything on whether or not I think there was enough in the record to sustain Judge Spurlock, I think it was Judge Spurlock's
Yes.
conclusion?
No, certainly not. I would ask that the court, if it were to find that The facts are indeterminate on the record, and it cannot affirm Justice Burlick on that ground. There are several other grounds on which it can affirm the result. And there's actually one more intervening step before we even get to resolution of the head-on conflict between the statutory mandates. And that, again, has to do with making out every element of the privilege claimed. The privilege speaks to the communications being privileged in a court proceeding or proceedings previous thereto, or in administrative or quasi-judicial proceedings, I think it's phrased. But it does beg the question, is this in fact a proceeding? And we would suggest that it's not. This is an investigation.
Would you take the same position with respect to the attorney-client privilege?
Well, the attorney-client privilege is not limited to a proceeding.
No,
It's
I
absolute.
understand that, but that if the board were conducting, it's an attorney-client privilege, and it's common law and so on and so forth. But the board could subpoena the records, and would you say that the board's interest in public health trumps the attorney-client privilege?
Not based on the common law. The common law, with respect to the attorney-client privilege, suggests on a number of axes that it's absolute. It outlives the client who's invoking it, which this privilege expressly does not. There's an exception for that. It attaches whether there is a judicial proceeding or not. This one does not. I would suggest that that is far more absolute and more far-ranging than this privilege is.
Well, let me just ask you this. You would read this language in the third paragraph of the statute to mean, well, gee, this is before there's a complaint filed, so it isn't an administrative proceeding. Is that what you're saying? I mean, doesn't that seem to turn it on its head?
Well, there is, to the extent that there's any evidence at all that the legislature was thinking about invocation of the privilege as against the board, and I'm not conceding that there is, but the only evidence that they were considering it in that light is the use of the term proceeding, because proceeding appears in the main part of the statute, which talks about when it can be invoked.
Let me ask you this, and I don't know what the answer is, but the general common law privilege, if you will, I mean, what Alberts versus Devine recognizes,
Yes.
just for a doctor-patient,
Yes.
would that apply here?
It would not, because Chapter 112, Section 5 specifically provides a safe harbor for any communications made to the board, either by a mandatory complainant, such as the physician who initiated this proceeding, and by any party responding in good faith to an information request from the board.
What
So I
would be
think
the
the short answer is
problem
no.
with requiring a hearing in circumstances such as these? Why do you have a problem with it?
Well, the problem is that this is at the very onset of the case. This is at the investigatory level.
But that there are facts that need to be established, primarily whether he devotes a substantial part of his time to the practice of psychotherapy.
Let me draw a distinction then. The board would very much have a problem with an evidentiary hearing at this stage if it were to consider issues such as relevance of the information being sought.
No.
I
The
didn't
hearing
say
is
that.
simply.
No, I understand.
So why do you object to it? I mean, it seems to be a question that apparently the doctor has some testimony that he would want to present to indicate that pain management is part of psychotherapy, so that in effect he says he's spending all his time in psychotherapy. What would be the problem with having a hearing?
Well, if the hearing were limited to the issue of whether the factual predicate of the invoking the privilege is made out, there would be less of a problem there. However, what I would suggest is that that's not necessary, because even if we were to concede that the number of hours he devotes to psychiatry is unclear on the record and needs further elucidation, and B, that this is a proceeding within the plain language of the privilege, even if we were to concede that it's at least conceivable that the privilege attaches, then we would get to the further analysis, which is the collision of the public policy underlying the two legislative mandates.
Well, if this is not a proceeding, could the board subpoena patients 1 to 23 and require them to testify?
Well, there are two problems with that. Number one is, as a matter of practice, the board treats investigations as confidential until such time as charges are actually filed. And it does so for a variety of reasons, including protection of the physician. There's a strong public policy against doing outreach to patients, saying, essentially, we're looking at your doctor, we think he may be providing substandard care.
So you're telling me you don't do that in the course of investigations? You don't speak to patients in the course of investigations as to whether a doctor is engaged in
Very rarely. And only,
But you can.
When the patient complains, for one.
certainly when the patient complains.
Or once you file charges, you do.
Absolutely, absolutely.
He's talking about as an investigation. And
At the investigatory stage, board policy strongly disfavors direct contact with the patients for that reason.
Is that because you're being respectful of the doctor or respectful of the patient?
Actually, both.
It's more respectful for the patient to obtain their psychiatric records and their confidential psychotherapy discussions than it is to speak to them directly?
Well, obviously, the board's position has always been that it is entitled to those records and would rather do so without alerting the patient to the fact that the doctor is under investigation. The other problem, specifically in a case of this nature, is this case, obviously, the allegation underlying this case is that this doctor may be facilitating drug-seeking behavior on the part of his patients. So as a functional matter, even if the board were to decide to go directly to the patients and ask that they waive the privilege, there's a very good chance that they won't.
All right, so if they won't waive the privilege, then the material is privileged, I take it. That's the board's view.
No, he's saying if the court says it's privileged, then.
Exactly. No, the board's view is and always has been that the privilege does not attach.
Are you suggesting that at the investigatory stage, this Superior Court judge could have ordered these patients to give sworn statements to the board or to the investigators?
As distinct from the records?
Yes.
If the board subpoenaed them.
If the board subpoenaed them, well, then certainly the analysis that applies as against any subpoena, namely, is it reasonable and is it
his office
oppressive?
His office burns down. There are no records. The only way to find out is to subpoena the patients and have them testify as to what went on in the office visits. Could a Superior Court judge order these patients to testify?
Yes, I believe he could have.
And it wouldn't be privileged?
No.
And what kind of a showing does the board require, or should be required before the board can subpoena these records?
Well, I would suggest, as in any other subpoena situation, a subpoena is the onset of a case. It's an investigatory stage. So the showings of relevance...
Privilege, it's not like in any other case. There's a privilege. I mean, there may be a privilege.
I'm sorry.
This may be a privilege. So I'm saying, I mean, what kind of a showing? Suppose somebody just doesn't like this doctor and comes up and says to the board, he's prescribing OxyContin to everybody in my block.
Well, the board's theory of the case is that the privilege simply does not attach.
Mr. Hammond, let me ask you this. Let's assume that you lose on the following 2 points. We conclude he is a psychotherapist, and this is a proceeding.
Very well.
Okay?
Yes.
And you're saying, notwithstanding those, nevertheless, as a matter of public policy, we should conclude that because of the substantial public interest that the board has, that you should be able to get access to privileged records.
Yes, Your Honor. In that situation, I would concede that you have a head-on statutory conflict.
I've read with interest the amicus brief from the Federation of State Medical Boards. It is not at all clear to me from that brief that how the FSMB deals with privileged material. In essence, it's saying you've got to get access to patient records, and I think that deals with the Alberts against Devine, but it doesn't deal with when you've got a statutory or common law privilege.
Well, does.
It says once you get the material, it's privileged, but it doesn't tell me. It says I mean,
Well, I think what the amicus brief concedes is that it's very hard to fashion a generalizable rule of law as among the different jurisdictions because some states have a common law psychotherapist privilege, others have it codified. Among the states that have it codified, some do contain an express exception for board investigations, some do not. Some of the cases that it cites are in reference to a physician-patient privilege, not a specific psychotherapist privilege. So it's very difficult to fashion a rule of law. What I think it speaks to, however, is the strong public policy underlying statutes like 112.5 that we have here in Massachusetts, which this court has on a number of occasions said should be construed very broadly because it's in the exercise not just of general police powers, but public safety powers, and therefore it should be read generally such that the board essentially has access to whatever it needs to carry out its investigations. If we agree, hypothetically, that Dr. Doe has made out everything he needs to make out to invoke the privilege, then I would suggest that you look at if it's a head-to-head conflict, yes, in the Coburn case, the supremacy clause would tell the court who wins. There's not much balancing to do. The federal will trump the state. Here we would have two state statutes in head-on collision, and the question is there any way that the public policy underlying both provisions can be honored? And given the de minimis nature of the disclosure here, which is to say the disclosure is only to the board, it will never be made public. The patients will be referred to as pseudonymously if there are proceedings that follow. The public will never know their identities. Given all of those protections, I would suggest that the trespass against their expectations of privacy is de minimis, and therefore the public policy underlying the robust policing of the medical profession would have to trump.
Thank you.
May I ask
Sure.
a question, please? Going back to a point you made, I think you were trying to make earlier. I think I understood you to say that Dr. Doe made a distinction between pain management and psychotherapy in his license applications. Did you say that?
I did, Your Honor.
Would you
yes.
explain that?
The record only, the only facts in the record are that when he routinely applied for the renewal of his physician license in 2004 and 2006, I gather there was a question asking him to describe his practice, and he affirmatively drew a distinction between the pain management part of his practice and the psychiatry or psychotherapy part of
And
his
is
practice.
that something that the trial judge relied on?
The trial judge was aware of it, yes.
Motion judge.
I'm sorry?
There was no trial.
motion
The Superior
judge,
Court
excuse
judge, yes, I'm sorry, yes. Yes.
Thank you, Mr. Hammond.
Thank you, Your Honor.